Welcome to Employment Law This Week. I'm George Whipple. Our top story, Justice Anthony Kennedy announces his retirement from the Supreme Court effective July 31st. Justice Kennedy was a key swing vote on the court, and a heated battle is expected over President Trump's nominee to fill his seat. On the same day that Kennedy announced his retirement, the court handed down a major labor decision. The 5-4 majority found that requiring union-represented government employees who are not members to pay union representation fees violates their First Amendment rights. The ruling overturns a 4-decade-old Supreme Court precedent, likely eliminating a major source of income for public sector unions. Kennedy was one of the 5 justices who joined in the majority opinion. Senate Republicans say they are determined to confirm President Trump's appointment before the court's 2018 term begins in October. Is the Department of Labor ready for a merger? The Trump administration is continuing its lean government agenda with a proposal for a new cabinet agency that would combine the Departments of Labor and Education. The proposed merger is intended to improve federal efforts to train the American workforce. The new Department of Education and the Workforce would be a single blended cabinet agency to be made up of 4 sub-agencies, including one dedicated to K-12 education and one to enforcement. Eric Moran has more.
What we are seeing is the result of the Trump administration's March 2017 executive order that required an agency-by-agency review of the federal government. The government expects and hopes to find some efficiencies and possibly some headcount reduction. And headcount reduction in an enforcement environment in particular could affect capacity, and it could result in a downtick in enforcement operations by the agency. This proposal faces an uphill battle in Congress. A cabinet-level change such as this requires 60 votes in the Senate. And what that means is the administration would have to win over 9 independent or Democratic votes.
A New York appeals court weighs in on the gig economy. A split panel concluded that a courier for Postmates, a web-based delivery service, was an independent contractor, not an employee, reversing the state's Unemployment Insurance Appeal Board. The court found that the company did not possess enough control over the courier's work for him to be considered an employee. Though the company determined the fees and tracked deliveries, it did not set his hours or require a non-compete agreement. Voters in the District of Columbia have approved an initiative to increase the minimum wage for tipped workers incrementally to $15 an hour, effectively eliminating the tip credit. The measure would make D.C. tipped workers the highest paid in the nation if it clears review by the District Council and Congress. The mayor and a majority of the council have come out against the initiative. It follows a measure passed in the district last year that will incrementally increase the minimum wage for non-tip workers to $15 an hour by July 1st, 2020. Under this measure, the minimum wage will increase on July 1st of this year to $13.25 an hour and eventually to $15. And that's it for Employment Law This Week. A busy week in the Supreme Court that may foreshadow a busy summer in Congress. We'll be following all of it here. Thank you very much for watching, and we'll see you next time.